For me, that's going to be the crux of this question. It's very easy for the state to do box-ticking exercise and say, sure, we looked at everything. The challenge for Huda Amouri's lawyers is, can they prove that they didn't do everything possible?
Right. Were there any particular examples of where Huda Amouri's lawyers had them in the corner on anything in particular? You know, can you think of any examples?
Yeah, sure. I mean, the state's lawyers had said there's been no chilling effect. So they said, although Palestine action was prescribed, direct action itself and protests in support of Palestine against Israeli weapons factories are still potentially criminal, but not terrorist. They haven't been prescribed. Justice Hussein made a very compelling point, and he pointed to a particular protest in Bristol at which the police said to people, any support for action against this weapons company may be perceived as support for Palestine action. So that blows the state's defense out of the water. That for me was a very compelling point.
Now, when I came on Monday, there was this thing of the stitch up with the judges that was overriding it.
Yeah.
And I think they took, the first day was Huda Amouri's solicitor lawyers, and the second day was the government's lawyers. What was on the third day then? What was this one?
It was closing arguments on both sides.
And what were the final arguments made by the government lawyers?
Essentially trying to reassure everyone that the Secretary of State followed protocol properly. Because, I mean, the Huda Amouri's lawyers were finding many holes in the process, evidence holes. Probably the most compelling is simply the fact that no other direct action group has been prescribed. So they say that shows clear evidence of discrimination against Palestine action. All the state has to do, and this is why I say the state always has the advantage, is to say, no, you're wrong, we followed the process properly, and we came to this conclusion. The problem is, we'll never know all of the information they have, and we'll never know what processes they went through, because a lot of that can be kept secret, right? Remember that there was a closed chamber segment to this trial today, 3 hours, when no one, including Huda Amouri herself, was allowed to see or hear the evidence being given.
Hold on, that just sounds just crazy. So is that an exceptional situation? Does that often happen? Where else does that happen?
To be honest, I don't know the process well enough, so Clive may know better than I do. I don't think it's exceptional, but it's certainly controversial. I mean, there was already an analysis in The Guardian a few days before criticizing these closed sessions.
But does that not give the judges the opportunity to make out, if they are just nodding dog to the government, to make out that they heard something that they can't disclose, that's so fundamental to the whole case that they can't allow a deproscription?
Well, possibly, or what it also allows, I think what's the bigger issue, is it allows the state to make maybe very compelling cases, but without scrutiny, right? So, for example, I mean, the spy cops inquiry is going on now at the same time.
Yeah.
It's possible that there are spy cops involved in Palestine action, and that evidence is going to be used. But if that's the case, clearly that puts the state at a huge advantage, and there's absolutely no way to challenge that evidence. That's a problem. That's not our definition of transparent, open justice.
And did they make any mention of when we might expect a judgment on this?
Today they didn't, but the last I've heard from them in general is January. It's going to take a while.
All right. Clive, you just mentioned there. What's your take on this closed court? What is it? This thing where we can't know what it is. Huda can't be there. What is it all about? And what's the precedent for that?
It is a quite bizarre procedure. So there is secret information, and what they say is because it's secret, you can't ever see it. So they give you a barrister, and this is a fully qualified barrister, and they're security cleared. You then have to instruct the barrister, and you have to instruct the barrister on how to represent you based on the information that you don't know and you will never see. And then the barrister goes in, and then the barrister tries to represent you. And then at the end of it, because the barrister now has a head full of classified information, they walk away and you don't get to talk to the barrister again. So you never get to know whether your instructions were spot on and they were exactly what was required, or whether the barrister walked in there and said, hold on, this is not what I was expecting, I am not ready to present this. There is a principle in law that someone accuses you of something, you see the accusation and you respond. And this just fundamentally breaks that model. Not only does it break it, because there's no security cleared reporters in the room, you don't know whether the process works or not. You have no idea whether the right thing is happening. For all we know, they went in there and they had a cup of tea and they played a game of chess and then they came out again. We literally do not know what happened in there.
When did this come in to play, this procedure?
Sadly we've had this for a few years now, and they put this in as a kind of tiebreaker because there would be circumstances where the government would say, well, we want a closed session and we want to present this information and we don't want anyone else to hear it. And then people would say, well, that's against natural justice. So we have this thing where supposedly you can instruct a barrister who will then go away and represent you, but we all know you can't instruct somebody to go away and represent you to do something where you've got no idea what they're going to do.
Saeed says he's not going to make any predictions. Have you got any feeling about where this is going?
The judges that you see in the High Court and the Appeal Court, they would make excellent poker players. They just don't show on their faces. Unless your case is really, really compelling or really, really awful, you won't be able to see it. And today they played a good game of poker. So we don't know which way it's going to go. In terms of when it's going to come out, the original estimate from Judge Chamberlain, who'd seen all the information as it was going through, was that this was going to be just before Christmas. Obviously with three completely new judges, and we've had no explanation of why three completely new judges were brought on. You'd have thought if they were going to have a panel, they would bring two new judges on to support Justice Chamberlain. Yeah. We don't know why that happened. They're going to take January. It will be at least January because they have to get their head around a lot of information, and they do not have very long to do it in, and there's just no way they will achieve that before Christmas.
Right, so I'm getting the feeling it doesn't look very good, but not many others are commenting because you're saying the poker face. I mean, the judges being changed, this closed session that no one knows about, that both of those seem so sinister that it's almost like it's a formality that the government's going to do. Can't I just put that to you in a game of poker? Would you say that as a hand that might be a good hand for me to put forward?
The poker analogy is a good one. If you were playing a game of poker and the person you were playing against suddenly changed at the last minute, and then suddenly they said, oh, we're going to change the pack of cards and you can't see some of the cards, you'd be there saying, hold on, this is not a fair game of poker. Yeah. So we're looking at it, and I think it's really important that the justices who are working in the court here understand, if people don't believe in the system, then they will not believe that they've had a fair trial. And if people don't believe they've had a fair trial, they will not honour the judgment. I mean, this is why we have open courts, this is why we have public galleries. David Lammy, this is why we have juries. Because people then believe in the process, and then people honour the end result, even if it's not the result they wanted. If you're going to have closed sessions, if you're going to suddenly change the judges who are hearing it, and you're not going to issue a single word of explanation, people won't trust it's been fair, and they won't honour the result. It's inevitable.
Well, I'm just going to. I know you've got to go off because you've been covering it all the time, but I really appreciate your time. Thank you.
Pleasure.
Now, Craig, you've just been all the way in Jersey this morning. Now, what you've heard about this case, this closed session, and the changing of the judges? It just seems so clear that the government's going to stitch this up.
They've done everything possible to stitch it up. I think people have to understand what closed session means. In the closed session, they present secret intelligence evidence, which nobody's allowed to know what it is. The lawyers for Huda and Morley are not allowed to know, even after the session, are not allowed to know what was said. They are supposedly represented by a lawyer chosen by the government, who has no contact with Huda and Morley, who he's representing. So he can't say to her, if they say you're funded by Iran, what do I say? He has no idea. So he's representing a client with whom he has never had any contact. And he's not allowed to tell that client what was said. So it's a nonsense. It's a complete and utter farce. Nobody has any idea what was said there. Almost certainly there's a lot of typical bullshit from MI5 saying, oh well, we have an intelligence source that tells us that they were planning to blow up the Secretary of State, or they were planning to take money from Iran, or that they're funded by the city of Westphalia or something. I mean, goodness knows what's being said. And there's no way of countering it. And when you add that into this last-minute change of judges, where we didn't just expand the judging panel, they actually took away completely the judge who'd been hearing it up till then, for no reason that anybody can tell. When he, right up until the Friday, 3 days before the hearing, believed he was the judge. Yeah. It's, they've done everything they possibly can to fix the verdict. I'm still kind of incredulous. There's no media here other than this Carlos and me. I can't believe it. But why isn't the media covering such an important story? Well, unfortunately, it's not a narrative that the media want you to hear. The media is state media and corporate media, and they're all owned by they're controlled by the government that's doing this, or they're owned by the billionaires who support it. So, real journalism is dead in the UK. There's no honest mainstream media. The actual media, people get real news from you, Crispin, and from me and a few others like us.
Yeah, and I mean I just find it unbelievable, because that's part of the problem. If there were more media, there'd be more scrutiny, and they'd be more likely to have to be transparent. If there's no media, then they can kind of get away with it.
Yeah, and my guess is we won't get a verdict now till middle of January, I guess, before any judgment comes out. We don't know for certain, but they don't seem to be in any hurry in that. And it's very easy to be despondent. But on the other hand, the government case was very weak. Of course, we don't know what was in the closed session, but the arguments for the proscription of Palestine action were weak, as put forward by the government. Their arguments that the European Convention doesn't apply were weak. There have been no real national security grounds. They gave no evidence at all as to the reported extent of damage done and the hundreds of millions of dollars of damage they claimed. They gave nothing whatsoever to substantiate that. They didn't really have an answer to the point that in international or damage to property is not sufficient to show terrorism. And we didn't really have an answer to the already existing crimes, such as criminal damage, which already already capture the offences. So they made a very, very weak case, and it's just possible that the case is so weak that some of the judges are intellectually just not prepared to debase themselves to accept it. We will have to see.
If Palestine action is not deprescribed, then there will be thousands of political prisoners, effectively, won't there?
Yeah, we have making arrangements to whack through about 2,500 people through the courts, 10 at a time, 10 a day.
That's more of a problem for the government, isn't it? If there's loads of political prisoners, I mean, people who are especially people older in life who've got some respectable background.
Yeah, I think once they start doing it, there'll be a massive public reaction. Once they start putting respectable, very often aged but decent human beings into jail for merely having opposed to genocide. I do think that despite their control of the mainstream media, there will be a tremendous public response. I think they are going to have a big problem. I don't think they thought this through at all.
Yeah, so they can stitch it up, but they're actually making it harder for themselves, maybe further along, and undermining the justice system. There's so much they're doing that's going to be negative for the government and the whole state.
The fundamental motive behind this, we shouldn't forget, is panic on their side. The government is acting in a state of panic, and the government's acting in a state of panic because it has been complicit in a genocide which everybody has seen. It wasn't able to contain the public reaction to that, so it acted to slap down on protest, to try to contain public protest by authoritarianism. That is the danger. That the government has tried to bring in extreme authoritarian measures, including this prescription, in panic. It's not been thought through. And they have lost control of the narrative, they can't get it back. For me, in this hearing, the key moment actually came on Thursday, where we were quoted a passage from the Prescription Advisory Committee report that recommended prescription, which stated that prescription was necessary because Palestine Action were hiring good lawyers when people were accused of criminal activity and people were being found not guilty. So, therefore, because people are being found not guilty, we have to bring in something else so they can be found guilty of something. That's quite openly in documents and was stated in court that they're doing this because juries are finding people not guilty. So this is a desperation attempt to restore the government's authority on the Palestine issue.
Right, and now I have to tell everyone, you've been in Jersey today. You've just got back from Jersey. Amazing. You win Liverpool at the weekend. I saw you up there. What happened in Jersey? Because Natalie Strecker was facing trial for terrorism there. Can you tell us what the verdict was and what you thought of the whole case?
Yeah, I mean, the great news is that Natalie was found not guilty. And I can't tell you how happy how delighted I am by that. It's wonderful to be there, to share that moment. And it was a terrible case. And the thing I want people to grasp about the Natalie Strecker case is she was facing up to 10 years in prison for 8 tweets. And those 8 tweets were less extreme than the tweets which at least 2 million people will have sent tweets more extreme than those. I mean, I've certainly sent tweets.
Don't say too much.
Well, I have. I have definitely sent tweets which are firmer than those. I mean, the government argued that to say that the Palestinian people, as an occupied people, international law, have the right of armed resistance. If you say that is illegal, that is terrorism. And the judge actually said to the prosecution, are you saying that if I give a lecture in international law, and I say that as a matter of international law, the Palestinian people have a right of armed resistance, and I say that to my law students, are you saying that is illegal? And the prosecution said, yes, that would be illegal. Which, as the right of armed resistance is taught in every single international law court in the UK, it's really quite a problem. It was extreme. The case was extreme. She was charged with tweets which make no mention of any prescribed organisation. And she'd made plain in plenty of other tweets she did not support any prescribed organisation. So that really was quite extraordinary, that she was prosecuted at all, and I'm absolutely delighted she was found not guilty.
And the fact it went to court is ridiculous. But I mean, she could have had a kind of charge, and then is it the CPS? I don't know what Jersey what happens there, but I mean the fact it went to court was a massive stressful thing for her. Is that what it was all about? Just to stress her out? It doesn't make any sense.
I mean, it's a truly horrible case. She had she had 6 armed policemen come into their flat at 7 in the morning when they arrested her and go through pedestrian in front of their small children, take all her papers, take all her electronics, all of those things. And then over a year waiting to come up for trial, facing up to 10 years in jail. It was just absolutely horrible. The process isn't part of punishment, of course, but I'd like to say it was Whitehall. It wasn't the local Jersey authorities, and the from Treasury solicitors here. They had a senior government solicitor, Alison Morgan KC, who sat there next to the local council. Only the local people had the right of audience in Jersey, so she couldn't speak. But she was obviously puppeteering the local lawyer and handing him notes as to what to say. Wow. So this was directed from London. It wasn't the local authorities in Jersey who were doing it.
So they got a bit of a bloody nose then.
Yeah, it certainly is a setback for them that they didn't manage to get a conviction. And I must say I'm absolutely delighted. There's one wrinkle in that which is important. What the judge said was that, and remember there's no jury, was that some of her tweets could be interpreted as support for Hamas and Hezbollah. It could be construed, was the word he used, as support for Hamas and Hezbollah. Personally, I don't see how, but he said they could be. But he was satisfied she had no intention of supporting Hamas and Hezbollah. And that's important because in Jersey, that's a defence. You have to have intent. In the rest of the UK, you don't have to have intent. There actually is no defence of not intending it to mean that. Because a couple of years after the Act was passed, Jack Straw specifically removed the defence of no intent. So if you accidentally say something which in the rest of the UK, but they've never removed it in Jersey by mistake, I think. Wow. But the particular technicality on which she was acquitted isn't available outside Jersey.
Wow, that's really, really stark as well. I'm learning so much that's sinister. The intent isn't a defence. I mean, that's crazy. And the stuff that went on in the court today with the closed session as well, and the barrister can't respond, can't tell the lawyers or who they what said. No, it's really good that you're doing all this reporting, Craig, and I urge everyone to follow Craig's blog because it's all got all the information, much better than anything I can get out, and it's all there so you can read it. Are you going to be writing all this up? I mean, you've got so much to write up now.
Yeah, no, I've been dashing around the last week. I haven't written up for your party conference yet. I haven't written up proceedings in here last week. Yeah, I've written up the Natalie Strecker trial, but not the verdict. I wrote up just before.
Oh, right, yeah, I saw that.
That's the tape. Now I've got a lot of writing to do. But tomorrow I'm going to Woolwich Crown Court for the Filton.
So you're going to have about 4 stories to cover in. You're just keeping going. I mean, it's incredible. Thank you very much for your time, Craig. Good to see you again.
Can I ask a question, Craig?
Yep.
Coming back to this case here, can we leverage the fact that we know MI5 lied in the past? There has to be some leverage in that, I would think.
Well, you would hope so. But of course, the judge who found that MI5 lied and who said MI5 lied was Judge Chamberlain.
Yeah,
who's a judge,
we know.
Who's a judge that they took off the case.
Right, right.
And of course, that may well be why they took him off the case. But the I should say, you've got some Judge Swift, for example, who has stated that security services were his favourite clients when he was a barrister, and who has taken a sort of hardline pro-government position in most of his questioning. I don't think they. Not all judges care that the security services lie. I think that's the problem.
So just to follow on what you made about the intents that's in Jersey, and of course there's no need to show intents in the rest of the UK. Would it be your contention that had Natalie Strecker or someone else been tried here in the UK, and following on, the government's intention to reduce or the number of juries that can go to trial, the number of trials that can go to jury, could someone like her have been found guilty in this country, more likely to have been found guilty in this country?
Yeah, there are a couple of things to unpack there. At the moment, although she didn't have a jury in Jersey, if she'd been here, she would have had, on that section, she would have had a jury. Right. And I would say, I have no doubt whatsoever that there is no jury in the UK that would have found her guilty.
The intention is to actually remove jury trials.
Once they succeed in removing juries from such trials, then the judge, if they followed the same ruling the judge gave in Jersey, would find her guilty, because intent would be, he said it could be construed, and here intent would not be a factor, so she could have been found guilty by a judge. So to that extent they've got the precedent they want. But of course not all judges would necessarily come to the same conclusion. I have no idea how that judge managed to come to that.
As good as we're relieved obviously for Natalie and everything she's been through, it isn't a complete victory for us in the Palestine movement. So, if we're just stating international law, someone has a right to armed resistance if they're being occupied. We never ever give a Palestinians a right we would have if France was occupying us. We would expect to be able to resist with armed resistance, but that isn't given to the Palestinians.
No, as I point out on my blog, I quote UN General Assembly resolutions, just giving the extracts from those General Assembly resolutions, which state the right of armed resistance, and presumably it's now, according to the government, it's an offence to quote a General Assembly resolution. You'd have to burn nearly every international law textbook in the country. It's elements of this are absolutely crazy, potentially far-reaching consequences. But I don't think, yes, it is a danger, but I actually don't think judges would be prepared to do it. I think this judge took the way out that was available to him. I don't think that means that other judges will go about jailing people for stating a simple fact of international law without even mentioning Palestine. It's quite it would be extraordinary, but we will see. But no, it's not a total victory. There are aspects of the judgment which are very bad, but the great thing is the ultimate result is not guilty, and I'm happy for that.
Well, thank you, Craig, again, and so we'll finish the live stream here. I have to say, unbelievable. We're the only. Well, there's another cameraman here, obviously, but no big BBC, ITV, anyone like that. But they'll be quite happy when all the arrests are coming, and they'll film all that kind of stuff. But
because it's not a good look to arrest elderly people who, in many ways, are disabled and are utterly peaceful, and retired priests and retired surgeons. It's not a good look, so they probably won't cover that. Like I've got pictures of disabled Quakers being arrested in wheelchairs. They're never going to show that because it just looks ridiculous. It makes the banning of Palestine actually just seem ridiculous. So yeah, I think if they could get some of Tom Robinson's lots suddenly supporting Palestine and being arrested, I'm sure they'd show that to show, oh look, look, he's supporting Palestine action. But they're not going to show elderly people being arrested because it just undermines their case completely. So no, I actually don't think, yeah. Sorry, yeah.
All right, we're going to sign off now, and thank you for watching, and please share, if you can, please share this video, because no one else is actually covering it. So It'd be helpful if you did share it.
In a genuine way, that they are defendant to see